Hi, legal writing students. I thought I would give a little, hopefully about 15-20 minute explanation of chapter 7 and this idea of identifying analogical categories. Remember, this word analogical is based on analogy, and it also has the word logic in it. So instead of saying, like we did with the very first memo that you did, where we're simply applying the law to the facts, we are adding an extra step in it so that we are thinking about how the law has been applied in some other cases, other situations, and then figuring out whether or not this new situation is more like one or the other, or in some cases, many others. So I've made a video slideshow that we'll use. First thing I want to point out that I've made some scheduling adjustments. I had it set up so that you would turn in 7-1 and 8-1 together. I decided you only need to turn in on Wednesday, April 21st, 7-1, and then the following week you can turn in 8-1. And this way, you can kind of work out the reasoning a little more slowly. She'd also say regarding the schedule that I've graded all the briefs that I received, and you should be sure to take a look at them, and you may revise them if you'd like to. Make sure you understand the reasoning in the cases so that you can do this analogical reasoning. So what we're going to do is talk about the segue example in the textbook. Basically, in the segue example, we're asking, how do the two cases relate to the scenario of the person who was given a traffic ticket for riding a Segway through a red light? Or another way to ask this is, do traffic laws apply to Segways? There were two cases in the Segway scenario. They were both made up by the authors of the textbook so that it would be easier for people to see. The Shipley case was about a child scooter, and the conclusion was that traffic lights don't apply. And the Monroe case was about a moped, and the conclusion was that traffic lights do apply. And so this idea of analogical reasoning is going to help us understand what the difference is, why the traffic lights apply with mopeds but not in scooters. And then the next step is to ask whether the Segway is more like the scooter or the moped. So I thought I'd do a little visual. Maybe this would help people see what the reasoning process is. So in the statute about red lights, they say that this law applies to any person driving a vehicle like an automobile. And so the question in each of these cases, Monroe and Shipley, and then it will be in the situation, the scenario situation, the question is a Segway or is a moped or is a scooter a vehicle like an automobile? And then what I've done in my chart here is just to put sort of placeholders in for these categories that we're thinking about to try to determine whether a Segway is more like a moped or a scooter, and thus whether or not the traffic lights would apply to them. And as they explain in the textbook, what you're looking for is to identify all the categories and then specifically identify those categories or that category that matters in the court's decision in the case. What they suggest is that you create a table and you identify the sources of information along the left and the categories across the top. And the key again is to try to figure out which categories matter the most in the court's decision. So the categories in the Segway case are the type of vehicle, the speed the vehicles can go, the weight of the vehicle, the potential harm to operator and others, how it's normally operated, and basically whether it's a vehicle such as an automobile. That's the basic question. And so that's going to be the sort of starting category. And starting to fill it out, we see, of course, that the red light statute describes the type of vehicle as a vehicle like an automobile. The Shipley case was about a scooter, the Monroe case was about a moped, and the Byrd case, which is the exercise, which is about the Segway. Note what I put up here, these are categories of fact. Everything that's going to be put in this table, except for vehicles such as an auto, are factual things. And these are factual similarities and differences. So making it the table completed, the type of automobile we've already mentioned, the speed is a category that might matter in the court's decision. So maybe a court will decide that those vehicles that are fast are the ones that should be treated as a vehicle such as an automobile. So speed is one. And the question is, does the speed of the vehicle matter in the judge or the court making the decision about whether it's a vehicle such as an automobile? Weight is a similar one. So we have a very heavy automobiles and we have a very light scooter. And perhaps the lightness of the, or rather the weight of the vehicle will be the category that matters. Then we have potential harm to the operator and others. So cars have a great potential harm. Scooters don't really pose a whole lot of danger to others. Mopeds may have some danger. And then this normal mode of operation starts getting at some other factual elements that may make a difference in deciding whether or not that type of vehicle should be treated like an automobile and then subject to the traffic rules. So a car has a motor. It also has an operator pressing the pedal and it becomes self-propelled, i.e. It can be out of the control of the actual operator. In contrast, the Child's Toy scooter has no motor and it moves only if pushed and it's not self-propelled, so that there has to be a person, pushing along the road and making it go. The moped is sort of in between those two. So it is motor, but the operator must push throttle. And like a car, there's no contact between the operator and the ground, and it's self-propelled. Now you might wonder where these categories come from. So I thought I would read the sort of the holdings of the cases with a little bit of explanation so that we'd see how these categories play into the reasoning of the court. So at the end of the Shipley case, which is on page 67, we agree with the defendant's argument. While there was no traffic and no one was injured, even if there had been vehicular traffic in the intersection, the defendant's two-wheeled scooter was too light and too slow to have presented a danger to vehicular traffic traveling through the intersection in the direction of the green light. The scooter could move only when pushed by one leg of the operator. Thus, it is too slow to be an impediment to crossing vehicular traffic. Further, the scooter is too light in weight to cause anything but cosmetic damage to other vehicles and thus cannot be dangerous enough to be covered by the statute. Thus, the two-wheeled scooter was not enough like an automobile to be subject to the statute. We do not mean to say, however, that every non-motorized conveyance is not subject to the statute. There may well be non-motorized conveyances that are enough like automobiles to fall within the purview of the statute, and we retain our prerogative to so hold. So notice what they're doing there. They're saying that the motorization of the vehicle is not the thing that mattered. What mattered? The speed and the weight all contributing to the potential for harm. So you can see back on our chart, the speed and the weight contributing to the potential harm is what they determine is the categories that matter. Now let me read Monroe case, the one about the moped. The statute clearly says that the statute requires anyone on a vehicle to stop for a red light till the beam becomes green. The defendant surely fits the definition of anyone. However, it is less clear that the legislature intended the statute to cover any vehicle. The only modifier for the word vehicle provides the example of an automobile, where it says a vehicle such as an automobile. Thus, this court must decide if a moped is a vehicle such as an automobile, and therefore whether the operator of a moped must obey the red light statute. While we reserve judgment on whether statutes concerning the licensing of drivers have any connection to the enforcement of traffic laws. So they're saying whether mopeds and cars have to follow the same licensing rules is not a category that matters. We do hold that a moped is enough like an automobile to be a vehicle under the red light statute. While it is true that the defendant's moped was not being operated under motor when the defendant passed through the red light, still the moped should be subject to the red light statute, whether the motor was engaged or not. While the presence of the motor alone is not dispositive, again, they're not saying this is the ultimate category that matters, although they're saying it does matter somewhat. While the presence of the motor alone is not dispositive, surely the legislature intended that a vehicle that could be ridden without any contact with the ground, and that was usually self-propelled, presented enough danger to crossing traffic and to the driver himself to be subject to the vehicular traffic laws. Further, unlike the scooter in the Shipley case, a moped under motor would be able to travel much more quickly than a scooter and is quite a bit heavier than the child's toy referenced in the case. So to go back, what they're saying is, the speed and the weight of the vehicle, of a moped, and the fact that there's no contact between the operator and the ground and that it's self-propelled means that it creates enough danger to others, including, they say, the driver. I will point, I'm going to correct my slideshow here. This should say yes, because that was their holding. It's a vehicle such as an automobile. Now, the assignment for this week is to do the final line in the table. So the question is the Segway enough like an automobile to